I welcome
Yeah,
it.
thank you, counsel. I'm sorry.
No, let's go.
Your friend began the argument by saying there were not, in fact, factual determinations. What precise facts do you think would be necessary to resolve?
So I think here the ultimate fact is the one that's at issue, is how much suffering was there. So, for example, I'll point the court to like the decision in TSC Industries about materiality. There are all kinds of situations in which juries get a question like, was the statement material, or pain and suffering, or negligence? And you have historical facts that could be undisputed, like here there were these threats, and we know what was said. But then what do you infer from that? How much suffering was there? How do you balance the fact that he was fine when he moved away from his hometown versus the fact that he was threatened several times and the threateners asked for money? And that kind of weighing is one for the BIA. Now, if petitioner succeeds in the argument that no reasonable fact finder, no matter how you weigh the evidence against him, no matter what inferences you draw against him, no reasonable fact finder could have found that there was no persecution, then he would win under substantial
evidence. Isn't that a
evidence.
legal question?
That question, when you draw all of the inferences, yeah. And that's what we say should be done.
So that's a legal question that judges can review under that pre-existing standard that Elias Zacharias speaks of.
That's correct, and that is our position.
And also you concede on page 40, as Justice Kavanaugh pointed out, that if there's some dispute about what the term persecution means as a matter of law, that a court can resolve that de novo.
Yes, that's right. And just to pick up on Justice Kavanaugh's earlier question about how that would work, I think this is very similar to what courts of appeals do in all kinds of contexts, and in fact what they are doing under the INA. So think of the example of a district court. There are all kinds of decisions that district courts make that are subject to abusive discretion review or clear error. And all the time litigants come and they say, okay, so here are my arguments on abusive discretion and clear error. But setting aside the way that the district court cashed out my particular facts, the district court used the wrong standard. And that is a legal question, and you have to correct the legal standard de novo. And the courts of appeals distinguish those things all the time.